So the first thing I want you to chew on while you're chewing on lunch are a few statistics. I see how I worked that in there. Pretty good, right? Now, number one, if you look on the screen here, we have some very interesting statistics to show you how our population is aging. Number one, by the time we make it to the year 2030, we're going to have 73 million people who are 65 and older, which is up significantly from 2014, where it was only 46 million people who were that age or older. So that population is expanding. Yes? We are on slide number 126. Yep, thank you. Page 42 in the book. Sorry, guys. And if we get off track too, again, just let us know. We'll show you where we're at. Now, the second statistic, all right, let's talk about who could potentially care for that aging population. Well, in 2010, there were approximately 7.3 potential caregivers, family members, for each person that age. But that ratio is expected to drop down to 4-to-1 by the time we make it to 2030, that same year we talked about. So we're going to have twice the size of that aging population and about half as many people who could potentially take care of them. Another one that won't surprise you is that about 80% of older adults say that they intend to age at home. I thought it'd be closer to 100. Look, everybody wants that, okay? However, that's not always the case. As Jeff mentioned earlier, we have about a 1 in 3 shot that you're going to need to go to a facility at some point in life. So although that's our desire, reality says something different. Another thing that you need to look at is when it comes to caregivers, again, we're going to talk about this in a later section, but every family member thinks they can take care of a sick loved one, right? We all think if our parents get sick, we can handle that. We can take care of them at home. But the last statistic on this slide should be telling for you. 6 in 10 people who've done that job have said it had a very negative impact on something in their life, right? Their family, their job, their careers, their ability to earn a living. Because the truth is, everyone has their own life, right? We can't just stop everything and provide care for someone, especially when we don't know when that's going to happen. So what do we do as we're aging, right? How can we get out in front of these problems? Well, one of the most important things to do is something very basic. You have to talk about this with people who are going to be involved with your life at that point, right? Be it your children, your spouse, anyone else. We put these things off, guys. Nobody wants to talk about things going wrong in life, but it's very important to do. Even personally, I've been through this. I lost my stepdad about 2 years ago, and although we were very close, we never really had that talk about what exactly is there financially between him and my mother. What exactly are his wishes? He's my stepdad. We didn't talk about those kind of things until about a month before he died, where we sat down for a few hours and had to go through in painstaking detail every account that he owned, what his wishes were. Not a good time to do that, right? So the earlier you can start that conversation with your family, the better off you're going to be. There's also a lot of other things you can rely on nowadays. There's a lot of useful tools that you can look at to sort of determine what other care options are out there. A place for mom, right? A website. That's a great one. If you don't know anything about any facilities, that's a good place to go and get some collective information to start figuring things out. If you a place for mom, yeah, a place for mom, yeah. There's also other things you need to do from a legal perspective, right? We talked about that all morning. Make sure that you have things prepared legally so that if something goes wrong, you can protect things. You have options. You have all your documents in order so that things aren't harder for your family, especially on top of you being sick. And then obviously managing medical care is a huge deal, right? Some of us are lucky and maybe have medical professionals in our family, and that makes it easier. I have a sister who's a nurse, God bless her. But not everybody has that, right? Sometimes you need to rely on others, other professionals to talk about these things. So having those conversations, like I said, is always difficult, but it's very important, especially as we age through life. Now, if you do get to a point where you've become less capable in life, right? You may need some care. You may need some help with some things in life. And the way we determine how much or what level of care you need depends on how much help you need with what we call the activities of daily living, all right? These are the basic things we all take for granted in life, folks. The ability to groom yourself, to transfer around your house, to take your own medication, to use the bathroom on your own. If you need help with at least one of these activities, well, at that point, you can qualify for what's called independent living. Independent living is a relatively low level of care, but it still costs money, all right? It usually adds anywhere from about $1,000 to $3,000 a month to your budget. Not an easy bill to pay sometimes. If you need help with two of those activities, well, then you can qualify for what we call assisted living or personal care, a little bit higher level of care, right? And for that reason, it's a little more expensive. That level of care usually costs anywhere between $3,000 to $6,000 a month. So again, pretty hefty bill. But if you need help with at least 3 of those activities or more, or if you have dementia that's severe enough, that alone can make you eligible for skilled level care. Skilled level care is legal speak for the nursing home. All right, that's the highest level of care that we deal with. Now, we also have some other government benefits I want you to know about, but first we're going to talk about how we pay for that cost, okay? This slide is actually old, all right? As Jeff mentioned earlier this morning, the average cost in being in a nursing home around here is around $12,000 to $12,500, maybe $13,000 a month. A huge bill, right? That's something that almost nobody can afford to do privately. But, you know, look, the main reason I have this slide on here is to maybe make the nursing home less of a demon in some people's mind, okay? Because I know the misconception everybody has out there, right? Nursing homes are these terrible places that just want to take all your money when you're dying. It's not the case, folks, okay? Nursing homes don't want to do that to you, all right? They're full of angels who take care of your loved ones at the worst time in their life. It just so happens it costs that much money to make that happen, all right? Has anyone here ever been in the ER before and had an aspirin administered to them? How much did that pill cost, right? A couple $100 on your bill? Well, think about what they're doing for you in a nursing home, folks. They're not just taking care of your health, all right? They're also taking care of you socially. They're cleaning for you. They're putting a roof over your head. They're feeding you. It just adds up, all right? That's why that cost is so high. And that's why you'll see that most nursing homes nowadays are Medicaid-approved facilities. It's because they have to, all right? When a patient runs out of money in a nursing home, the nursing home could throw them out. Believe me, they're allowed to do that, all right? But they don't want to for a million reasons. You don't want to do that to somebody, and who would take their parents there, right, if that was your practice? So when a patient runs out of money in a nursing home, the nursing home is going to get them on Medicaid because Medicaid pays the nursing home pretty well. All right, it pays them 85% of their private pay rate. And like I said, guys, the unfortunate reality is that because it's so expensive, it's almost a guarantee that somebody in their nursing home is going to run out of money, right? So that's why almost every facility we deal with nowadays accepts Medicaid. But of course, everyone wants to stay home, right? I know that, all right? Everyone wants to try and avoid going to a facility. But if you don't have that option, that's the cost you're going to be faced with, all right? Now, when it comes to a cost that's so extravagant, all right, how in the world do you pay for that if it happens to you? Well, you have 3 options, okay? The first one is probably the least realistic for most of us. You can open up your checkbook, start writing checks for $13,000 every month, and hope you have enough to get through it, right? Again, not something most people can do. A second option you can look into is you could purchase a long-term care insurance policy, all right? Some of you are probably familiar with those. It sounds wonderful in theory, right? You buy an insurance policy, and that policy will pay the nursing home if that happens to you, so great way to solve the problem, right? Well, here's the catch with long-term care insurance policies. You used to be able to get a really good policy back in the day that would cover the full cost of care, and it would be something you could afford, all right? That's because the insurance industry hedged a bad bet. They didn't realize how many of us were going to need skilled level care, and they drastically underestimated how expensive it was going to become. So nowadays, these policies are still out there. They're just a little harder to come by, all right? They're very expensive, and they usually don't cover the full cost of care anymore, all right? It'll pay for maybe a half or maybe 2/3 if you're lucky, and they limit how long they'll pay, all right? We see it everywhere from maybe 6 months to 2 years on average is what I see. I don't know about you, Jeff, roughly, right? And as we know, that might not be long enough to get you through, okay? But I do like these. These are very good in certain situations. For example, let's take one that Jeff used earlier. Say you have a married couple and the husband has $1 million IRA, but the wife doesn't even have one, right? They just put all their eggs in that one basket. Well, who is it more important to keep out of a nursing home financially then? Husband or wife? Husband, right? Because if he goes in, what do we got to do to that $1 million IRA? Got to liquidate that thing. So that's a situation where I would tell that couple, look, send the husband around to see if just he can at least get a policy, right? Keep him out of the nursing home because financially that's going to be a lot better. The other thing I like about long-term care policies is they will also pay usually for lower levels of care. All those things in between nursing home and healthy folks like independent living, personal care, assisted living, these are all private pay in Pennsylvania, all right? And I know they're not as expensive as a nursing home, but they also are not cheap, as we just talked about. Sometimes long-term care policies will also pay for those lower levels of care as well. So there are benefits there. But to me, the third way to pay the nursing home is the best one. You can let the government pay through Medicaid, okay? Medicaid is a program that Jeff is going to teach you about in great detail here this afternoon. And what I'm going to do is I'm going to summarize what he's going to tell you, all right? If you're a married person in Pennsylvania, we can follow Medicaid's rules and protect 100% of the assets and get the person on Medicaid. If you're single, widowed, or widowed, we can use those same rules to protect at least half of what the person owns and again, have Medicaid pay for that care. And that probably sounds like I just told you that unicorns are real and Jeff and I flew on one here today. But like I said, he's going to tell you exactly why that's true, all right?
Unicorns aren't real?
Shh, don't tell anybody yet, all right? I told you I have that one in the garage, all right? Now, again, guys, before we get to that part, there are a few other government benefits I want to draw to your attention. We've mentioned VA aid and attendance a few times here today, all right? We've brought that up a couple times. It's honestly not something we do a lot at our office because not many people can qualify financially anymore. And working with the VA is very frustrating, all right? It's very hard to get any kind of answers or any kind of results out of that. So we actually send that kind of work to people who do it exclusively. They have a better chance than we do at it. The other thing I want to bring to your attention, though, is what's called the waiver program. Waiver is where you ask Medicaid for an exception. Instead of paying for my care in a facility, pay for my care at home. And they can do that, all right? There's a few other contingencies that come into play that Jeff's going to tell you, but a very nice option because, again, like we started out with this section reading, 80% of people want to age at home. That's where they want to end up, all right? And that can allow that to happen. Okay, well, that's going to take us into special needs planning, and I'm going to hand it off to Jeff, who's going to tell you a little bit more about that in detail here.
That afternoon when you start to come down, right? So let's talk a little bit about special needs planning. The one thing that I usually mention at the beginning that I didn't mention earlier, so I'm going to do it now while I'm thinking about it, is we built this program essentially in 1 hour segments so that we can pull one out, go into the community with it, teach this, teach that. Two reasons I'm telling you that. One is if there's any community events that you'd like us to speak at, we would love to, and we can pull any one of these sections out. But the other reason is because there will be a little bit of redundancy, like in this special needs section. We're going to talk a little bit about POAs. That's because I literally could pull this out and take it into the community by itself. So we'll skip through that, kind of fast forward through it, but I wanted to let you know that as well. Obviously, a parent wants to protect their children. No question about that, and ensure that they have the best quality of life absolutely possible. When you have a family member with special needs, obviously some of the planning changes, right? Some of the priorities change, some of the planning changes. So what we have here is we're going to talk a little bit about the difference between POA and guardianship, right? You know the difference between those two from this morning. There's a thing called a testamentary special needs trust. So what do we know from the morning? Testamentary means a trust that's created in a will. And what has to take effect for the person to die? Or for the... Yeah, I gave away the answer. The person has to die. You're right. You got it. All right. And we touched briefly this morning on some of the issues that we're running into currently, with that. So that's where we're looking to pivot. And there's something called a standalone special needs trust. There's standalone special needs trusts that we can do. Typically, the parent, the grandparent are going to be the ones that will be creating those. What government programs are available? Well, most of them fall under DHS in Pennsylvania, Department of Human Services. We've got different programs like energy assistance, food stamps, waiver programs, Medicaid or medical assistance. What are the asset tests? Typically around 2,000 for SSI, 3,000 for married couples, and then we get into some of the other income tested programs. Social Security or social insurance, diagnosed as disabled, income earned less than $1,180 a month, assets less than $8,000. You're going to learn when we get to the Medicaid section, assets can be either $2,400 or $8,000 depending on the income. So we'll address that in a little bit. Some of the benefits can be disability, SSD, SSI, or Medicaid or Medicare. And when we're applying is the death of a parent becomes totally disabled, or the parent retires 62 to 65. Person with a disability has worked at least 6 quarters. What are some in-kind benefits? MHIDD, which is a newer name, state and county funded. There's early intervention programs, some camps, some respite care, family-driven services, and residential care is provided as well. We know, what do we want to do if we can? Avoid a guardianship, right? At all costs, we want to try to avoid it. In Pennsylvania, the statute says all adults 18 and older are presumed to be competent or to have capacity. In order for that to change, there's only one person in the world who can adjudicate that person as incapacitated. Who is that? Judge. That's a judge. You are correct. Thank you all for paying attention. It is greatly appreciated. Now, you probably have already figured out by now that we don't take ourselves too seriously. Is that fair? Dan and I and Carrie are 3 of the most laid-back people you will ever meet. So I want to introduce you to my special needs planning workshop that we give. You will notice a smiley face or a sad face. All right, that's going to pretty much tell you whether it's a good idea or a bad idea. So option 1, outright gift. If you leave an outright amount of money to an individual receiving government benefits, what happens? They lose the benefit. Okay, so not a good idea, right? So people got cute and they said, wow, we don't want to lose benefits, so we're just going to give it all to one of the healthy children. So if we've got 3 kids, we're going to write out the child with disabilities or the individual with disabilities, and then one of the 2 is going to get all of it. Now, how does that work? Yeah, I mean, you know, in a perfect scenario, it could work, right? But the problem with the morally obligated sibling is that even if the morally obligated sibling intends to be a good human being, if that individual dies, becomes disabled, gets in a car accident, gets divorced, it's outside their control, right? They can intend to be anything, but in some cases, they can't control it if they wanted to. So that is not, in my opinion, a good idea either. All right, we're just going to disinherit the child altogether. The logic here is the government will take care of my child. The government benefits that they receive will be enough. That's not my experience. Now, that's just me talking. Certainly, I'll anyone in the room that wants to share another experience. I think we have good programs. Please don't get me wrong. I think that we have some great group homes. Medicaid is providing great, but they still need stuff. There's still extra things that they don't have access to. So disinheriting them altogether and just relying on the government, I don't know if I love that idea either. The option that we like is still provide for them. Give them their third. Treat them the same, but do it in a special needs trust. Do it in a way that the money's protected for them. And when they die, the money can then pass on to your heirs, to whoever you want the money to pass on to. Okay? This is the option that we like, which is why there is a smiley face. Just in case anybody was wondering. There is something called support trusts. Support trusts are typically for people with a lot of money and people who say, look, I don't want the government benefits. I've got millions. I'm just going to take care of my child, and I'm going to provide a trust for health, education, maintenance, and support, right? I'm okay that they're going to lose benefits, because what happens if the standard is health, education, maintenance, and support? They lose benefits, right? That does not qualify as a special needs trust. That's a support trust, and we see the sad face. So we don't want to do that. Yes?
states, but the terms for special needs, is it special needs or supplemental needs?
Every state uses them differently, and they use them interchangeably. Some states say that special needs is third party, supplemental needs is first party. To me, I use them interchangeably. You can, in any situation, they are used in a way to provide benefits and not lose the government benefits as well. So the special needs trust for Pennsylvania, the decision was the Lang decision. So I just throw that out there. Did you have a question, Denise? Oh, so I just throw that out there for the high fact finders in the room who like to know. So Lang is the decision that provided in Pennsylvania that Pennsylvania allows for them. The distribution amount must be made for the sole benefit of the individual at the discretion of the trustee. Okay. It is to supplement, not supplant government benefits. So those are key words. Those are very key phrases that you will see in the document. This is intended to supplement, not supplant. Not used for support. It's simply there to enhance the government benefits. What are some examples? Unreimbursed medical expenses, vacation opportunities, visiting family members, camps, private vocational trainings. We always say everything other than food and shelter essentially is what you're going to be providing for in regards to the special needs trusts. As I mentioned, you have two choices. You can create them now or you can create them at death. We traditionally always waited until death. What is the number one way that people fund to be able to pay for individuals with disabilities? Life insurance. Life insurance, definitely the number one way. So what we would just do is do a will, do a special needs trust in the will, direct the life insurance to the testamentary trust. At death, it pays out. Everybody wins. I don't know. I mean, we haven't had any issues so far with special needs trusts, but again, I think you're probably going to find over time that most companies are going to end up stopping altogether. The one thing we see in our industry is once it happens once or twice, it's usually a sign of things to come, and it's all going to change. So we're preparing to be doing a lot more living trust in the future. When I gave this presentation 6 months ago, my answer was, there's no reason to do a living trust, created at death, it's easier. Now I'm saying, we might have to do that.
So what's the rationale you get? Why do they not want to?
Well, I think, and correct me if I'm wrong, I think from their perspective, it's not in existence. So they're saying we're targeting or funding something that isn't there. And what we're saying is, yeah, it's the trust under the will dated May 5th, 2003. And I'm guessing from their perspective, something must have happened in a case or two where maybe a date changed, maybe money didn't go where it was supposed to. I'm not exactly sure. No one's actually told us the why. We've had 3 companies so far that have caused an issue. And with 2 of them, we were able to come to a resolution. I don't think we have with yours yet. Am I right, Angie? So my fear is, up until recently, we were always able to come up with a solution. This is the first one that I'm not sure we're going to be able to.
One other reason that one of our wholesalers gave for this is the potential for a scam, is what he was told when he asked about it.
Yeah, so what one of the advisors in the room is saying is that he was told by someone that one of the reasons they're pushing back on naming the testamentary trust as scams. Yeah, I mean, I haven't heard that there were any, but, it's kind of one of those things. And again, I think we're headed that way because it's the third one and they're not ultimately bending. So far, we've been able to come to a solution, so we'll see.
Banks, brokerage houses, or insurance companies that you've experienced?
Both, insurance and banks. Yeah. Yep. So we'll see where it goes. I think ultimately it's going to end up, because the guy on the phone said to us, I don't know if it was your company necessarily, Angie, but one of the companies said to us, well, you just do living trust like everybody else. And I said, because I don't see the benefit to the client. He goes, what do you care? You get to charge more and you get to make more money. And I'm like, at this point though, what choice do I have? But that ultimately taught me, okay, he's like, you're making this harder on yourself for no reason, Jeff. There's a solution that will work. Why are you trying to make it harder? Because I felt like it was better for the client. That's why. Now, if they're being scammed, I certainly don't want them to. I mean, I hadn't heard that until Angie mentioned it, but certainly I would never want anyone to be scammed, and none of our clients have been, but we're going to do whatever they tell us. So if we can't come to a resolution, then for that client, we'll make them right. We'll probably do an RLT for them and then, fund it into the RLT. We'll figure it out. I mean, we'll make it right. But then moving forward, we're going to have to make tough decisions, which means you might see living trusts occurring more special needs trusts that'll be standalone during lifetime probably as well. People will start to do that as well. So either way is fine. It doesn't make a huge difference, honestly. Option 1, living trust. So we create it during lifetime. We let it have its own entity. We let it create its own. We can start funding it now. The advantage of that is it has its own tax ID number. Other individuals can fund to it too if it has its own ID number. So there's an advantage to that. Option 2 is in the testamentary trust, and that occurs and is funded at death. And other people can't fund to it if you do it that way. So if you do it in the testamentary trust, other people cannot fund to it. All right, so far we've only talked about the parent and the grandparent. All right, so what if the parent, the grandparent, the brother, the sister, they want to provide for an individual with disabilities? No problem, right? We do a special needs trust. We create it in the will. We create it in the living trust. Takes effect whenever you say it takes effect, and that money is available for them. We can pay out for anything other than food and shelter, right? What happens if I'm the individual that has a disability and I'm the individual who is receiving the benefits, but my money goes over $2,000? Maybe I work part-time. Maybe I received an inheritance. Maybe I got a lawsuit. Maybe I was injured in a lawsuit and I received a large amount of money in a lawsuit. If my money goes over $2,000, what happens to my benefits? I lose them, right? So the government created this thing called a first-party special needs trust, right? Or supplemental needs trust, to go back to the example that she gave. And what that is it's an animal that the government created so that you can keep your money and keep the government benefits while you're alive. But then at your death, the state has a right to get paid back to whatever is in that special needs trust that's left over. Okay, so with a first-party trust, the state has a right to get paid back. Why does the state have a right to get paid back?
By benefits.
Yeah, because they allowed you to receive benefits and didn't make you spend them before they allowed you to receive the benefits. So their logic is, well, if there's any money left over in the trust, we should get paid before it can go on to other family members. In a lot of cases, there's a third-party trust that was created by the parent or grandparent, and then the individual over the course of their life ends up getting a first-party trust, whether it be from an inheritance or a lawsuit. Which one are we spending first? The first-party one. Why are we spending the first-party trust first? Yeah, because that has to be paid back, and the third-party one does not. So we definitely want to understand the difference between third-party and first-party. First-party has to get paid back. Third-party does not. Does everybody understand the difference between first-party and third-party? Third-party is Jeff's parent, grandparent, brother, sister. First-party is Jeff earned it, Jeff received it, or Jeff was entitled to it. Once it touches Jeff, my social security number, it's mine. Once it's mine, I'm left with the first-party trust option. The downside is that there's a payback. What we like to do is to just set up all documents that have a standby special needs trust so that there's never a situation where a person dies and there was outright distributions. It always goes to a special needs trust. What type of special needs trust would that be? Third party, no payback. Do you see the difference? Over time, one of our largest referral sources for years were group homes. Right? We had a great relationship with a lot of group homes. Why? Well, the individual might work slightly. They receive Social Security. They have some income coming in. $2,000 is a low bar. $2,000 of assets doesn't allow you much room, right? So every month, these group homes are having to buy TVs and buy whatever just to keep people under $2,000. Well, it's a lot, right? You might have 20 people living in a house, or however many people, and a lot of them are having this problem. So what the group homes were doing is they were referring it to us to create first-party special needs trusts so that we could accumulate 20, 30, 40, 50,000 and then go buy them something real. Go buy something substantial, as opposed to let's just spend them down every month with crap to keep them below the threshold. It worked out well for them. It worked out well for us. So then I think what happened is the government started to see it, and the government said, all right, we don't love that they're having to spend money on a lawyer to create a first-party special needs trust. Why don't we create something called an ABLE account? ABLE. It was approved federally. Every state has their own version of it. Every state approved it. And what that is basically a way to provide for an individual with disabilities, and it's actually a little broader than what it would be if you were paying out of a first-party special needs trust. So there are some things you can pay out of an ABLE account that you can't pay out of a special needs trust. I want to show, let me get there. Third party is by anyone other than the individual. First party is if it's my money and I create it. ABLE is an opportunity for us to have money set aside for the individual. But I want to show this chart. Now, you may not be able to read this, but I'll read it to you. Medicaid payback upon the death of the beneficiary. ABLE, remaining funds must be reimbursed to the state for Medicaid benefits. Special needs trusts. First party must be reimbursed to the state. Third party, no reimbursement required. All right. Here's where we went south. Pennsylvania made a decision. They were not going to go after money in an ABLE account that is left over. Okay? I was presenting in Harrisburg, and there was a lady from the ABLE office. I put up this slide. I said that comment. Her hand went up, and she vehemently disagreed with me. And she put me in my place. And I acknowledged. Currently in Pennsylvania, we are not going after money left in the ABLE account. What was the key to what I just said? Currently, under this administration, we have made a decision not to go after the ABLE account. The federal law says what? The states can. When the next administration comes in, could it change? Sure, right? Absolutely. And she said, well, but that's not what it is today. Here's why this is significant. Just had a meeting this week. Parents put $15,000 a year for the last 2 years into the ABLE account. Okay. Had they done a third-party trust in their will or in their living trust, if they had one, would there have been a payback requirement? No. By putting it into the ABLE account, $30,000, they've now just subjected it to what? The government. And their response to me was, we were told to do that. I know. I'm not disagreeing with you. By people at the ABLE office.
Yeah, of course.
Because they believe they don't understand that the next administration comes in. That's an easy source of funds. Right? I don't know about you, but they got to come up with a lot of money. That's a pretty easy way to come up with money. It's the federal law. Why make an exception?
Jeff, as it is currently, where do those assets, if the special needs person dies? Is it?
Under the ABLE,
Yeah.
you would name a beneficiary. And then it would go to wherever you want. And the beneficiary would still be named, but the state would just have a right to get paid back first.
Right.
And then if there's money left over, the beneficiaries would still receive it. And I hope it never changes, and I hope I'm wrong forever. But this family this week was very upset with me. And I literally pulled out this chart because I felt like they were going to attack me. And they're like, you're wrong. I'm like, no, I'm not.
How would that play out? A beneficiary dies, or excuse me, the special needs beneficiary dies.
Yes.
ABLE account exists. There's a named beneficiary in the ABLE account. What's the time period that would be involved. How long does the financial institution hold on to that money, waiting for the bill to come from the state before they transfer it to the beneficiary?
Well, they have to. I mean, with one of the requirements, and Dan covers this in the afternoon. Am I right, you? One of us is going to cover this afternoon that we have to write a letter at every estate asking the state whether the person was receiving medical benefits and whether there's a lien. It's a requirement, whether it be in any situation, we must do it. So I think what you're going to see there is if the position changes by the state, then essentially the banks will just hold it until the letter is received. Now they don't have to. I mean, now I think it's First Third Bank is the bank that has most of the ABLE accounts in Pennsylvania. I'm sure right now they're just distributing pursuant to the beneficiary. But if the state ever came in and changed that, they would have to hold it and wait until the letter comes in. Now the letter's coming quick. It's amazing how when you write the government, how many months it can take to hear back from them. If you write them a letter asking how much they're owed, you get it quick. It's funny how that happens.
Quick question. I have a 32-year-old sister that's autistic. My mom and dad are meat and potatoes kind of, my mom is my sister's caretaker. Would I be able to, and I'm not sure how this would be defined, if my wife and I, knowing and being a planner by trade, knowing that at some point, given my mom and dad's health is not in the best shape now.
Okay.
If I want to start planning as far as anticipating her living with me at some point, can I, without their consent, set up a special needs trust for my sister as a third party?
Sure, you can create a trust for anyone.
Okay.
With your money, you mean?
Yeah, with
Sure.
my money.
Yeah. You would just create the way we just mentioned, a third party. What I don't want you to do is put it into an ABLE account thinking it's a little broader, so there is a benefit to it. So what's happening is banks and the ABLE office are telling people like you, we'll put it here because it's more flexible. And there's no payback provision. Correct, currently. So yeah, you can absolutely create a third-party trust, and you could fund it with life insurance. You could have your whatever assets you want. If he has his IRA or retirement assets funded into the special needs trust, what's the payout? Is it a stretch out over the life expectancy, or is it a 10-year? If you had another choice. Life expectancy. Remember, special needs trust was the only one that they made the exception for. So I realize, depending on the severity of the disability, it may or may not be a good idea, but I'm just saying we have to pay attention to this stuff.
If I may add, there's a lot of gaps in this, especially with, like what you had mentioned before, as far as the mindset of a parent. My parents are divorced. My dad will not give anything to his special needs daughter simply because he's aware of the rule that anything over $2,000 is going to be held against. So that almost makes him feel as if he's exempt from being able to care for her.
Right.
At the same time, the whole family is, pardon my French, screwed if something happens to my mom and there's no human value approach as far as her value in this equation. So I'm trying to get them to see that part as well as a gap that,
Yeah.
God forbid, something happens to her, predeceasing my dad then has to come up with money to replace her as the caregiver.
Right.
And that's
So the situation that he's talking about for people not in the room is sister has a disability. Father doesn't necessarily see the value in leaving any money to her because the government will take care of her and she's taken care of. Currently, the mother is doing all the caregiving. The mother is brunting the care. And he's saying, if mom dies, there has to be a value on mom's life. What she's providing, there's a huge value there. But my dad isn't taking steps to provide for her. What gives? What's going to happen? Yeah, definitely. So I just really wanted to focus on that for a minute to just stress it, because this week was another one. It's happened 5 times now. And 5 is not a lot. But again, when you start to see it, it tends to, there's others out there, right? We're only one law firm, and I've seen it now 5 times. Paul?
Is there any way to transfer assets between ABLE and special needs trust?
No. The question was, is there ways to transfer between these two? And so far, I've not seen that. I've not seen people allow it. So currently I'm saying no because no one's done it that I'm aware of, and I haven't been told otherwise.
Jeff?
So yes.
In the situation what the gentleman was talking about, his sister, if, wouldn't, if that trust couldn't pay for caregiving expenses, could they? Would it?
Sure. Yeah, you could set up a trust to provide for caregiving expenses.
So that's outside of, I guess, shelter and.
Correct, and food. Correct. Yeah, and they're getting much more lax too. I mean, it was food, shelter, and clothing that you couldn't provide for. And then they dropped the clothing and they said, you know what? We don't want to stop people from buying clothes. Like that seems a little crazy. And I think the government also is acknowledging that the amount of money that they're giving isn't as much as they used to think it was. And I don't think the dollar isn't going as far, frankly. So I think they're trying to make changes to stay with the times as far as the government can do, right? So there's one more option for somebody who has not yet turned the age of 65. Same with pooled trust, first party trust. You want to fund those before you turn 65. With a pooled trust, it's essentially a nonprofit. And then you put all the money in a pool. It's still available during my life for me. But then when I die, instead of it going back to the state, it goes to the other individuals in the pool with the same disability that I have. So that's another option. Pooled trusts, ARC has one, Special Needs Alliance has one. What's the group out of Pittsburgh that we use? Achieva has one. So there's a lot of pooled trusts in Pennsylvania that are there for individuals with disabilities. So that's also a great option. So when we're talking to families with individuals with disabilities, our comment is the next step is to talk to a professional who understands special needs. You want to make sure you're getting advice from someone who understands the benefits, how you can keep them, and those types of things. Oh, is this me or you?
I mean, it's me.
Oh, go ahead, man.
Take a break.
Yeah, I'll get a drink. I like it.
For you. Okay, guys, we're going to get in and talk a little bit more about that caregiver situation that I mentioned earlier. Now, the first thing I'd like to talk about are some statistics once again, because let's just ask the room. Has anyone here ever provided care for a loved one who's sick, acted like a caregiver in the past or currently? Wow, lots of you, okay. Very easy to do, right? Didn't infringe on your life at all, right? Didn't hurt your career or your time at home or your spare time, right? Very easy thing. Well, obviously, I'm being facetious, folks, right? When it comes down to finding a caregiver, you basically have two options. You have family and you have everybody else, all right, a private person. So that's really your only two options, and a lot of us actually end up in that situation. Again, this is a statistic from about almost 10 years ago now, but in 2015, we had 34 million Americans who provided care to someone who was over 50 in the last year, right? That's a lot of people. And the value of that caregiving would have estimated to be about $470 billion worth of care, which is more than Walmart made that year, all right? So it's a huge economic strain that we don't think about, all right? Because everyone assumes that if you're a family member, you do this because you're a family member, right? But the reality of society today doesn't really allow for that all the time, right? Like I said, most people are in dual income families. We all have jobs. Raising children is harder nowadays because of the activities they have. It's just a very hard thing to do because there's no time to make it happen. But it is a very common situation, okay? Obviously, that's who we want to take care of us, is our family. It's something that most people would prefer because it's personal, right? It's hard to decline with your health and go through hard times. So if a family member can help you out, that's usually a lot more comfortable than somebody you don't know. Now, these are just some more statistics to show you what this looks like here in Pennsylvania. Again, our state population, when this statistic was taken back in 2013, we had just under 13 million people who lived in Pennsylvania, and 1.6 million of them acted as a caregiver. Right? That's a pretty big percentage of that population. Again, the total number of hours that were provided in that year were 1.5 million. The economic value was around $12.47 an hour. It's a lot higher now, almost $20 an hour we see. And the total economic impact there in Pennsylvania was just over $19 million. So this is a big problem. It's a big issue that we deal with. Now, when I come across this situation, and it's obviously very common, a lot of the families that Jeff and I and Carrie work with are going through that, right? One of the parents perhaps is declining in health, so the kids are going to step in, and maybe someone's going to even step up and move them in, right? Or move in with mom or dad so that they can be there all the time to care for them. Again, the days of this being a situation where we assume that should be for free are kind of getting away from us, right? Most parents who need care nowadays understand that that's a sacrifice that their loved one is making, and they want to compensate their loved one in some way. Where this becomes complicated is when we deal with Medicaid as well, right? Because if what happens is usually the case, that parent will say, look, I'm just going to write you a check every month, all right? Let me live here. You can take care of me, and I'm going to give you $2,000 every month, and then just do what you need to with that money, all right? Make it work. Well, if the person needs Medicaid within the next 5 years, Medicaid is going to make an assumption, all right? They're going to presume that that money you were giving to your child every month, that $2,000, was a gift, right? Come on, it's your kid you're doing that with. So what we do to keep that from being a problem nowadays is we have the parties to that problem enter into what we call a caregiver agreement. It's just what it sounds like, folks. It's a contract between the person who's providing care and the person who needs it, so that everything's memorialized and spelled out specifically as far as what they need and how much they're going to pay. And if you do that, the benefit is Medicaid will now no longer view that as a gift, right? Those were not gifts. Those were payment for services under a contract. So the way that we make a valid contract is it has to have these following requirements met. Number one, like any contract, you got to have it in writing. All right, it's got to be written down so that everybody can be clear about what the obligations were. The second important thing that you have to have with any contract is you have to have what they call consideration go back and forth. There has to be some form of payment for those services. Now, it used to be where people would try to do these in lump sums. You can see how that might look suspicious, right? Uh-oh, I'm getting sick. Life is getting hard. I have $200,000 in my bank account that will keep me from getting Medicaid. So, child, I'm going to pay you $200,000 to take care of me for the rest of my life, right? Easy. Well, those have become a little bit less favored, right? Obviously, Medicaid could look at that a little differently. If the person needs care right away, they're going to say that was just a gift. So what we typically do nowadays is we do it by a monthly payment, all right? We break it down per month, and that's how we do it. The contract has to be specific, all right? It can't just say I'm going to give my child $2,000 a month to take care of me. It has to specifically list exactly what that child or what that person's going to do for you. It has to specify how long that's going to happen, and it has to be signed by both parties. That becomes an important part to this, okay? Because a lot of times, by the time you need a caregiver agreement, capacity could be an issue, right? You may be having somebody act as your financial power of attorney at that point. Well, the Department of Human Services does not want to see the power of attorney sign that document. They want to see the actual patient be the one that signs it. Now, when we do these contracts, like I mentioned, folks, we have to be specific about exactly what we're going to do. And this is where it starts to look a little goofy, okay? If you move your parent into your house, what you've done is you've turned your house into the facility, all right? Now you are the facility. So you have to specify in that contract exactly what you're going to provide as a facility. Is it going to be their own bedroom? Are they going to have access to their own bathroom? You have to say that they have access to common areas like the dining room or living room so they can watch TV and eat meals, right? Again, we have to be very specific with these things so that they know the patient is going to have those at their disposal, right? They're the sort of weakened party in that situation. Now, we also talk about not just the lodging, but what is the person going to do for the person they're caring for, right? Are they going to cook for them, buy food, prepare meals? Are they going to clean, do laundry for them? Are they going to provide transportation to and from doctor's appointments or financial appointments, right? These are all things that we specify in detail in the ones that we do. And what we do at our firm is we just basically put how much time per week the caregiver is going to spend doing certain things, right? How many hours a week do you spend preparing meals for your loved one? How many hours a week do you spend doing their laundry? How often do you have to take them to the doctor or the dentist or the eye doctor, right? And we add all those hours up and we basically assign it an hourly rate. roughly around $20 an hour is what we do nowadays. And that adds up fast, okay? It may not sound like that would be all that expensive, but this relates back to why nursing homes are so expensive. Do the math on that, folks. When you add all those things up, you'd be amazed how quickly you can get to an $8,000 or $9,000 a month payment just to have somebody be taken care of. Again, we talked about this, but the compensation, we typically don't do lump sums anymore, right? That's just a big red flag for Medicaid. They think that that's just a trick to try and get away from obviously divesting yourself with assets. So like I mentioned, we do these on a per month basis. And so long as Medicaid sees that the person is spending less than what it would cost to be in a nursing home, Medicaid's typically okay with these, all right? That's sort of the limit that they look at, because if you're paying somebody less to take care of them than Medicaid would have to pay, you're doing Medicaid a favor, all right? You're saving them money in that regard. Now, the big issue here with caregiver agreements is a tax issue. If you are providing care for your parent and they're paying you for that, the money they're paying you is income to you, all right? So a lot of times family members overlook that. But that's a huge important thing to keep in mind, because if you're being paid $4,000 or $5,000 a month to care for your mom and dad, well, that's a lot of income through the course of a year, all right? And that's really the litmus test that Medicaid looks at to see whether or not this was legitimate, all right? If you're actually paying income tax on the money you're receiving, they say that it absolutely is a contract for services that they'll recognize. Now, there's a couple different reasons we use these. I'm being sort of, I don't want to say disingenuous, right, when I say that we only do them to pay for the care we need. But remember, most people are willing to do that for almost nothing a lot of times. So what we can do with caregiver agreements is we can actually use them as a tool to spend down somebody's resources to make them eligible for Medicaid. I had this come up yesterday, as a matter of fact. One of the most common scenarios I do this is for a single person, all right, who sees that their health is declining sometime in the near future. They don't want to go to a facility because nobody wants to go to a facility. So what they want to do is they want to become eligible for the waiver program in Pennsylvania. Remember, that's when Medicaid will pay for your care at home, but it has the same basic rule Jeff is going to tell you about in a few minutes. There's an asset test, right? You can't have more than $2,400 or $8,000 in total assets in order to qualify for that. So if you're a single person and you have, let's say, $200,000 in your bank account, you're not going to qualify for waiver anytime soon, right? You have all that money you have to get rid of. Well, if you're living with one of your children and they're taking care of you, what you can do is you can start paying your child $8,000 to $9,000 a month to take care of you, right? And that's a quick way to get that $200,000 out of your name. It puts it in the name of your child ultimately, right? And then you're eligible for Medicaid waiver, right? You can get waiver at home. So we don't just use those to memorialize exactly what's going on. Sometimes we use them as a tool to get that person spent down so that once the money's gone, Medicaid can take over and help with the care from there.
If you have a trust, and I guess the supplemental needs trust is pretty much the same thing, right?
Yeah.
So she gets the income, out. If the caregiver, can that caregiver be paid out of principal?
Remember, the principal of that supplemental needs trust can be spent on anything other than basically food and shelter, right? And one of the most common things that's paid for is extra medical care, right? Extra therapy, things that aren't typically covered by your government benefits. So absolutely, they could use that principal to pay for somebody to help them, give them care, give them transportation, any of those things absolutely can be used with that. Yeah, yeah. Yes.
Quick question. With all COVID and everything, with the limited beds and things for individuals that got sick during that period of time, sometimes they had no choice, but they had to sell their house and go into some type of assisted or nursing home to where it wasn't Medicaid approved facility, and it's a non-Medicaid approved facility in the case that I'm working on now. How hard is it to be able to transition from, because right now they're just writing out a check, and in the state of Pennsylvania, if there's debt unpaid, that's a filial liability, right? But in the event that they transfer over to a Medicaid approved, then it's not.
That's what it all boils down to, is Medicaid approved versus non-Medicaid approved, right? There are still facilities that don't accept Medicaid, that are just private pay. Even nursing homes that are Medicaid approved you can also private pay, right? And where you hear problems with people getting into certain facilities is when they try to go in on Medicaid. Because facilities typically only have so many beds reserved for Medicaid patients ahead of time. Not many, in fact. But anybody can go in and private pay and then get on Medicaid. Any bed can switch to a Medicaid bed. So if they're in a facility where they're not happy with it for whatever reason, right, whether it's financial or otherwise, you can always go to a new facility, right? It was crazy during COVID because there just weren't beds at all. There wasn't a place to be anywhere. And that's where COVID was bad, all right? Nursing homes were where it was really bad and raging, and I mean, it was just a nightmare for that reason. That's clearing up a bit, thankfully, you know what I mean? So it is becoming a little easier nowadays to transfer or go to a new facility because they actually have some availability. But your person could easily go to a new facility that is Medicaid approved and just switch over to Medicaid at that point. I'll speak to the elephant in the room. You know, we used to hear Medicaid approved facility and think that that was a bad place to go, right? It was different a long time ago. There weren't many Medicaid approved facilities because the cost wasn't as bad. But now that the cost has gotten so high, like I mentioned earlier, almost every facility out there has to take Medicaid if they want to give good service, because otherwise they either have to rely on a benevolent fund or their own money to pay for people that run out, or they have to kick them out, which they don't want to do. So that would be my advice. They could look into transferring to somewhere that does take Medicaid. And
There's a spectrum between, there's a spectrum within the Medicaid-approved facilities to where you're sharing a room with 4 people with a curtain across, or there's other ones to where you're paying, you know, a good amount per month. But to be able to maximize what money they still have, that could be wrapped
Right.
up into what you guys are talking about.
100%. Yeah, absolutely. And there is a range, you know what I mean? They're all different. And that's what's crazy. You'll see some of the nicest facilities you'd ever imagine are also Medicaid approved, down to ones that aren't so nice are also Medicaid approved. There's a wide range in there. So a lot of options, but like I said, caregiver agreements are becoming more and more common because of all those statistics I started with, folks. Like I said, a lot of us end up being in a position where we try to do this for loved ones, but we quickly realize how difficult that is from a time perspective and a financial perspective. And that's not good for either the sick person or the healthy person. So these caregiver agreements, like I said, are a great way to kind of bridge that gap and make it a more formal solution that works well for everybody. All right, well, that's going to take us to VA aid and attendance. I'm going to hand it back off to Jeffrey here, our resident VA aid and attendance expert, who's going to tell you about that. And then he's going to walk you into the roles of Medicaid right afterwards.
Testing. VA aid in attendance. Woo! Yeah. Huh? Is that good? Yeah. Nice. So I think the first thing I want to comment on in regards to this section is that the game changed. 2015, and I'm going to put my personal spin on this so you know how I feel about it. In 2014, 2013, Congress kept going, my apologies, the VA kept going to Congress saying, please change the law, please change the rules. We as a VA do not like that people are allowed to do a trust, an asset protection trust, where the grantor remains in control and it's in their social security number. We've heard those, right? We don't like that they can use those style of trusts, put the money in there, and then immediately qualify for the benefits and be able to receive income. For a veteran, I don't know, let's call it about $2,300 a month of income. For a surviving spouse of a veteran, let's call it about $1,300 a month of income. Congress said, no, we're good. We have no issue with it. We provided for it. We funded for it. Somebody who fought for our country and served 90 days, one day of which was active wartime, if they can get a couple $1,000 a month to offset their cost of assisted living or a nursing facility, we're fine. Well, VA didn't like that. Now, I don't know if I'm being naive here. I thought the Veterans Administration was supposed to be pro-veteran. I don't know. When Congress said no, the VA went and found some obscure rulemaking authority that they had to change the law. So the VA went on their own motion and accord under a rulemaking authority, changed the law and said, if you want to qualify, you have to do it 3 years ahead of time, 3-year look back, and you cannot use a trust that you're in control of. You have to use a non-grantor tax-style trust. Well, remember, in a non-grantor tax-style trust, what tax rate are we at? The trust tax rates, right? You're up at the highest, 39.6%, when there's like 17,000 of trust income in a year. Whereas an individual would have to be over, was it 440 or whatever that number is right now. So they caused a problem, you like that? I changed that word, in 2 places. 1, 3-year look back, and 2, using a trust that is not favorable for the grantor. So essentially what happens? No one's doing it. A, planning ahead and giving up control for a benefit that may pay you $2,200, $2,300 a month is a hard sell, right? You got to tell somebody they got to give up control and access. Well, when else would I have to do this? Only when you had more than 12.06 million and your spouse had more than 12.06 million. Well, I have less than 130,000. I know. You know, where I've got 180,000, I've got 200,000. They're not doing that. That doesn't make sense. So, I mean, I'm still approved with the VA. Technically, we could still do apps, but to be completely transparent, what we have found is in York in particular, the individual who was so against it is no longer there. He retired. He was a dear friend of mine. And I remember we had lunch one day and I said, Phil, can I ask you a question? And he said, yeah, Jeff. And I said, you spent most of your life in the military. He said, yes. And I said, so what you're saying to me is, if you ended up needing to go into an assisted living facility and your kids and your wife could save $5,000 a month by doing, you know, a trust and qualifying under the VA for the VA aid and attendance, and now with that benefit plus your income, you would not be out of pocket a penny. You wouldn't want them. Absolutely not. That wasn't the intent of that program. Okay, you're the only crazy man that I know, but that's cool. Hey, you do you, man, right? So to this day, he swears that that's the case, and I choose to believe him. But everybody else seems to think that if the benefit's available and Congress was okay with it, I'm cool with it too. That's not the law anymore. So we have found now it's easier once we get somebody down under 130,000, we just refer them to the VA, and they do the app. They have access to inside portals that tells them where the app is, how long it will take. Whereas when we file, we don't have access to that stuff. And I have always found when the VA does it, they get a result much quicker than we do. I don't know if that's intentional or not, but there's no reason really. We can't get paid to do the service. The VA can't get paid to do the service. They have access to things we don't. It makes sense for the VA just to do it. Let's talk about it though, because some people are spent below 130, right? Now, if the house sells, it's considered an asset, and retirement's considered an asset. So we're talking people under 130, like legitimately under 130. Veteran, widowed spouse, or dependent or disabled child. I do want to say this. It is the surviving spouse of a veteran benefit. In order for the surviving spouse to be eligible, what has to have happened to the veteran? They have to have died. Thank you. We got a call and the lady says, I'm calling to inquire about the surviving spouse of a veteran benefit. And I said, oh my God, what happened to Fred? She said, what do you mean what happened to Fred? I said, well, it's a surviving spouse of a veteran. You're not doing something stupid, are you? She goes, no, I don't know what you're talking about. She thought that she could qualify for it if he was alive. So I said, well, surviving spouse, he needs to be dead. And she said, oh, okay, well, all right, how does that, in what circumstance? I said, whoa! He just has to be dead. I don't think they ask questions. Anyway, the veteran had to have done 90 days, 1 day of which was active wartime. The discharge had to be anything other than dishonorable. I was not in the military, but I know there's a lot of discharges that you can receive. As long as it's anything other than dishonorable, you're good. Similar to Medicaid side, activities of daily living, we're looking at whether or not the veteran needs assistance with 2 or more. Now you'll notice this list is a little more encompassing than the list for the Medicaid side. It includes some IADLs, bathing, dressing, toileting, transferring, eating, grooming, walking, and taking meds. So this one takes into account some instrumental activities of daily living. The other one is just ADLs. Financial requirements, they must be under $130,000. As I said, if you sell the house, it is considered an asset. If you try to put the house in a trust, you have to do so how many years? 3 years ahead of time. Essentially, here's the payouts of the amounts. It's up to $2,400, so I was wrong. I said $2,300 a month, so it's up to $2,431, so that's good. That benefit's starting to go up. It is tax-free, so I did want to mention that as well. And some examples are assisted living, independent living, as long as it's for protective reasons. So you actually have to get a letter from the independent living community that says it's for protective care or protective services being provided.
What does that mean?
I don't know. Anyone in the room in the healthcare that wants to explain what the protective, the letter literally needs to say that part of the fee is going for protective reasons for the individual. I think it just means that they have to give them extra care. They have to watch them more. They have to keep an eye on them. Is there anyone in the healthcare that has a different answer? Yeah, that change happened a few years ago, and I went to a doctor and said, "Doctor, it's an independent living. I need you to say that part of this is for protective care." And he wrote the letter, and we mailed it into the VA, and he called me, and he said, "What does that mean?"
Like suicidal?
I don't think it's that far. I think it could be just as much as we have to assist them with taking their meds. We have to watch them going down the steps. I don't think it's as bad as suicidal, but it was just funny to me that the doctor wrote the letter and then called me and said, "What does that mean?" I said, "I don't know." He goes, "Well, I figured it's getting the money. What do I care?" I said, "Yeah, that's kind of how I feel." But I don't think it's quite to that level of suicide. I think it literally is just we provide a little more care for this person. Because remember, what's an independent community? You're supposed to be living independently. Whereas this says they need a little extra care.
Fall protection.
Yeah. Health insurance premiums, the co-pays, prescriptions, hospital bills. The number one reason is for usually assisted living. Assisted living can range anywhere from $3,500 to $5,500 a month. You get $2,400 a month to offset it, plus the income. Usually a veteran can take care of themselves, which is, I think, what it was intended for. Now we have a 3-year look-back period. And remember, we also now have to use the non-grantor style trust. We still use caregiver agreements the same way as we did. Dan explained it for Medicaid. We also use it for VA. You're not seeing a ton of applicability right now just because of how low the amount is. I hope that they go back under their own rulemaking authority and change their mind, but I don't think they will. I think you're going to see it's a 3-year look back, and I think eventually they'll move it to a 5-year to match Medicaid. I'm surprised they didn't just do 5 out of the gate. I mean, since Medicaid was 5, you think they would have just matched it, but I guess they do have a heart after all. So you guys are getting tired. It's the afternoon. That was a good joke. You missed it. Did you? But all right.
To your heart.
Yeah. Medicaid. All right. Let's talk a little bit about Medicaid, and then probably we'll be up against a break at that point and stretch our legs and kind of get ourselves back up. Medicaid is a federal program that essentially is administered by the states, and the state gets to interpret the federal rules the way that they want. I do want to take a minute because I happen to look at the screen. So I want to say hello to Deb and Sherry and Christine back at the office. Our entire Medicaid department is watching the entire boot camp today. They are phenomenal. There is nobody better in the country than them, and I just want to give them a shout out. So we have an incredible Medicaid department. They're amazing. And so they're all on. So hi, guys. All right. What are the eligibility requirements? You have to be a citizen, a Pennsylvania resident. Jeff, what does it mean to be a Pennsylvania resident? Are they residing in a nursing facility in the state of Pennsylvania? Yes, they're a resident of Pennsylvania. Okay, that's how easy PA makes it. Some states make you live there for 6 months, for 12 months. PA does not do that. If you're residing in a facility, you're a resident. 65 plus, blind or disabled. You must be medically eligible. Assets have to be less than 2,400 or less than 8,000. The number that we're going to make that determination on is the income of the individual less than 2,523? If it's less than 2,523 a month, then they can have 8,000. If it's greater than 2,523 a month, they can have 2,400. Do you see how that works? If it's greater than that amount, they can have, wait a minute, did I say that backwards? If it's greater than 2,523, they can have 2,400. If it's less than 2,523, then they can have 8,000. What income is counted? Well, primarily we're looking at what? The pension, Social Security, like what income do they have? All right? Don't count IRAs because remember, in order to qualify, what do we have to do? We have to liquidate it, and so that income won't be there anymore. So we're looking really at just pension and Social Security. Okay, once you're qualified, we're going to allow you to keep $45 a month as your personal needs allowance. Please don't spend it all in one place. We're also going to allow you to keep the health insurance premium amount of the applicant only. Jeff, can I withhold the amount for the community spouse? No, it's for whom? Only the applicant. Now, we're also going to allow a certain amount of income to go to the spouse, the community spouse. We'll talk about that in a minute. Look at this beautiful chart. I love this chart. It will get more full and kind of all the examples will be built into it. Currently, we have two types, exempt and non-exempt, or not countable or countable. And then watch how it gets full. It's exciting. Okay, what are some exempt resources? There are going to be some things that we're going to allow that are going to be exempt, a residence. Okay, let me just verify this. 636,000. So the excess home equity limit is currently 636,000. So you can have a resident that is under that, and we can exempt it. Property used for trade or business, essential for self-support, or non-business property, essential for self-support. Household goods or personal effects. We're not going to go in the house and take the painting off the wall. We're not going to take the rings off of grandma's finger. But if the painting on the wall is a Monet and it's worth $1 million, that's a different situation, right? Pigs get nurtured, hogs get slaughtered. Yeah, so be a pig, but don't cross that threshold, you know. And a lady asked me, well, where's the line on that? If you're asking me that question, it's worth too much, all right? If you have to ask about a painting and what's too much, I believe you better disclaim it, right, or sell it. Next asset is a motor vehicle of reasonable value. All right, so let's play a game. Reasonable value, 30 grand, reasonable? Yes. 40, 50, maybe. 60. 60 is our threshold? Anyone want to say 60 is okay? All right, 70. All right, now we're losing everybody. All the people nodding, they're lost. We exempted one that was 75,000, but it had a lift kit, wheelchair accessibility, right? So it's and you were exactly right. It depends. No, I don't think you could exempt a Ferrari or a Porsche worth 75 grand. But this specific vehicle needed to be that way to take the spouse in the wheelchair and get her in and out of the vehicle. They're not cheap. If you've ever bought one, they are very expensive. So they do look at the specific circumstances of each case. I do not believe that there is a flat number. Every time we've done it, we've always explained why it is what it is. To today, we've never had a case where we were told it wasn't reasonable value. So, life insurance policies, face value up to $1,500. We talked about that earlier. Term life insurance policies, they're fine. Why? Because there's no cash value. Burial spaces, irrevocable burial reserves. There is a chart in your handouts that has the amounts for every county. Every county is different. So because we're in Lancaster, and of course we have a lot of clients in York and Harrisburg and Adams, we just decided to put the chart in there for you so you could see all the counties in the state of Pennsylvania. The Community Spouses Qualified Retirement Plan. I'm going to repeat that one more time. The Community Spouses Retirement Plan. Jeff, is the retirement account of the applicant exempt? No, only the community spouse. So a lot of times when people are in our office and they're asking questions, you can see me smirking for those of you in the room so you know I'm about to say something stupid or funny. And people will ask, well, what should we do? And I say, well, who's going to go into the nursing home first? Because if one of you's got $1 million retirement and the other one has zero, let's hope the one that doesn't have it. You know, like, well, that's not good planning. Yeah, I'm aware of that. But I don't know how it's going to turn out. So I can't tell you what to do unless you can tell me who's going to need the care. But I think it's important to acknowledge in Pennsylvania, this is, okay, remember I said there wasn't much that Pennsylvania did for us? Here it is. Exempting the community spouse's retirement account, a lot of states don't do. A lot of states make them liquidate that too. So at least we have that in PA. So we got that going for us.
Community spouse income.
Yep, we're going to talk about that in a minute. Yep.
That irrevocable burial reserve.
Yes, sir.
I have this printed out on my desk at my office because I saw. Do you know why there's such a difference from year to year? I mean, in like Lebanon County,
And
it's
county.
up like $4,000.
And county to county.
Yeah.
Yeah, I don't know why, but I do know it changes often.
Yeah.
And I'm always relying on the ladies back at the office because it's constantly changing.
I do campaigns with my advisors regarding that because that goes against the countable asset.
Yeah.
To expend it.
Right, it's part of it's an exempt asset. You're exactly right. Yep. All right, so we have 3 types of asset transfers. Exempt, for value, and gifts. Common exempt transfers to the spouse or to another for the sole benefit of the spouse. To the child if disabled, under 21, or blind. House to the caregiver child of the applicant. All right, so what does that mean? Let me take a minute here and stop with this one. If you have a child who lives in the house and provides care, and because of the care that the child has provided for the past 2 years, the applicant has not needed to go to a nursing home, we're able to transfer the house to the child without any penalty, and it's not a gift, it's an exempt transfer. You do need a doctor to put in writing that the child provided the care, and because of the care, the person didn't have to go to the nursing home for at least 2 years. Jeff, the grandson is in the house providing the care. Can we use the grandson for the exemption? Please all say no. No. What do lawyers always want to do? Change the facts. It's the child caregiver exception. It's not the child, sometimes grandson exception, right? You have to meet the rules. The rule is it has to be a child. Now, I would go on to say natural born or adopted, right? Because Pennsylvania treats adopted the same as natural born, so that I would say is okay as well. The other exemption is the house to the caregiver sibling of the applicant with an equity interest in the residence. I think this used to be way more common, right? Mom and dad leave the house to the 2 kids. 2 kids own the house. 1 kid lives there. 1 kid has an equity interest. All of a sudden, one needs care. The other one's living there to provide the care for the sibling. We can exempt it to the other sibling. Jeff, does that go for the grandson? No, right? It's not the sibling, sometimes grandson exception. I don't know that maybe a handful of times, maybe 3-4 times we've done it in 20 years. Not something that comes up very often.
What about daughter-in-law, son-in-law?
No, daughter-in-law and son-in-law. Now we need the son or daughter. I think the in-laws are not allowed as far as I know. You don't know of any different, do you?
Jeff, like you said, the state could impose a certain value on a vehicle.
Yes.
What about the child's providing caregiving in 2 years in a multi-million dollar state? Is that
Well, I think that the question was, this is how a speaker buys time to come up with an answer. You ready? So the question in the room for the people on video land was, if a child is a caregiver providing caregiving for 2 years, and because of that care they stayed out of the nursing home, could you transfer a multi-million-dollar property? My answer would be it's still subject to the equity value that we talked about earlier, which is $636,000. I think that excess value goes across the board. So if Sherry or Christine or Deb back at home, want to comment, feel free, and Steve can let me know. But I would believe that it would follow the same equity exemption amount. As long as it was under $636,000, it could be. I don't think that they would let you do $1 million property. I think they would keep the same equity excess allowance. Yeah, I've never had that happen though, but they're pretty finicky about, anything over 636 I'm actually surprised it's that high, to be honest. But the reason for that though, I think, is in like Philadelphia, I think you can get some properties that are worth 600 that aren't huge, whereas around here, most $600,000 properties are pretty big. It's just different areas of Pennsylvania.
But you would think that they follow the logic that if you're going to be paying for the care for a year or 2 years in a nursing home at $13,000 or $15,000 or whatever it is a month, that would be the limit.
Yeah, so his argument is, but you would think it would be based upon the amount of care that they're providing. It would be $13,000 a month times 12 months, or however long they're providing care, 24 months in the 2 years situation. That's logical. Medicaid is not typically logical. Again, it goes back to what does the handbook say? And immediately, where did I go? This is one thing I always teach when I'm training Medicaid is go to the handbook. And all I know in the handbook is that there's one property excess allowance amount, and that's $636,000. So unless you can show me an exception, I'm going to go to that rule. Because remember the caseworker that told me, I'm not here to think, I'm here to follow the handbook. So I'm following the handbook. It says 636. Unless I'm told otherwise, that's the number. Doesn't have to make logical sense. All right, transfers for value. So this is just purchasing something for value. I'm going to pay for nursing home care. I'm going to pay for living expenses. I'm going to pay for legal fees. I'm going to pay for admissions into a facility fees. They're fine, right? As long as they're reasonable, they're not exorbitant, we're good. Purchase of exempt resources. So if you're purchasing an exempt resource, that's a transfer for value. No problem. Go ahead. You mentioned earlier about buying a irrevocable burial reserve. That is purchasing of an exempt resource. That's a transfer for value. No penalty. Now, don't go over the amount. He had said a great comment that every county is different and it changes often. And I agree with both of those statements. So make sure that you follow the rules for the county that you're in, right? Because they go by the county that you're in as far as the amount that you're allowed, which can cause an issue, right? Because if you're in York County preparing, and then you end up going to some smaller county, you could get yourself into an issue. That's probably a bad example. I probably should have used like a Philadelphia county moving, because some of those numbers, there's some of those places that you can spend up to $18,000, $19,000 on funerals. But if you move then to an area or living in an area that it's only 10, you could have a penalty there. So you have to watch.
I have a question. Back a few pages, but in regards to the Medicaid eligibility, are blind pensions, are they considered separate from?
Say that word again?
Someone that's blind.
Okay.
That's receiving like a blind pension. Their income is so low, they're receiving.
Okay, they're receiving a blind pension. Okay.
They're receiving a blind pension, and they get into a car accident. She's hurt really bad. She gets a whole bunch of money through a settlement of a car insurance accident. I assume that's going to knock her out of eligibility.
Yeah, unless you put it into a first-party special needs trust.
That's what I thought.
Yeah, which has a payback provision. Yeah, I wasn't sure if you were going somewhere asking a question about income, and I'm like, oh crap, here we go. But that question I can answer without any hesitation. If there is any amount of money received by somebody on benefits because of a settlement and inheritance, the only way to avoid it is the first party. Remember the rule. Once it touches the person's SOCH, you can't hide it. You can't make it go away.
What if she had a whole bunch of medical bills in which there's a lien? Could you have a Medicaid lien on the benefits that she should have gotten as a settlement?
Could you have a Medicaid lien on amounts that she should have gotten as a settlement? I don't know. I don't know. To the extent that it's for the same state that you're in and they're providing benefits, I would just call DHS and explain the situation and say, hey, I got a case where money's coming in, but you already have a lien. You know, I guess it doesn't matter though, because under a first party, they still have the amount they get to get paid back anyway.
She's just worried that once she gets off, she can't get back on again, even if she puts that money somewhere else.
Well, she could put it in a first party trust and stay on benefits. Yeah, the downside is we want to spend it during her lifetime because there's a payback. Yeah, one thing we do very well is work directly with DHS. Anytime there's money coming in, call someone who knows what they're doing. I mean, we call third party recovery, make sure they know up front. We work out the details. You can work all that. It's so much easier to work it out ahead of time than it is to worry about it later. Paul.
So, someone needs care and they have a $250,000 mortgage on their house. They've got $250,000 in investments. They need care today. No, we can pay that off. No
Yeah.
impact, no issues.
Yeah, so the question that Paul asked was, person needs benefits, $250,000 of assets, $250,000 in a mortgage. Paying off a mortgage is definitely an exempt resource. That's okay. Now, where we're going to get more complicated, in a few slides, we're going to go back to what Denise mentioned earlier, which is, okay, if there's a spouse, right, I can take that excess 100,000, whatever the number is, turn it into a qualified, Medicaid qualified annuity, pay it directly back to the community spouse over 3-4 months. The community spouse ends up with 100% of it. So that's a counseling issue, right? Because some spouses would rather the $250 excess in money. Some spouses might rather just pay off the mortgage and have no money. I'd rather the money, right? But you guys are far smarter than me. So that's where it gets interesting, because in some cases you might choose to leave the mortgage, because I can get the money back to you and then allow you to just continue to pay the mortgage. But yeah, you could just pay off the mortgage and qualify. You might not want to do that. So, all right, gifts. It's a 4-letter word. All right, Dan did the 3 lands today, but I just want to reiterate one more time. Just because you're allowed to do something in tax land doesn't mean that you should do it, right? For every action, there's an equal and opposite reaction. And in every land that you make a decision, there's another land that's going to slap you upside the head. Now, you still may choose to do it, absolutely, but know the consequences. So for those of you who are advisors, you know that if a client asks me, should I put my kid's name? Should I add a joint owner? I stand up out of my chair and I say, let me introduce you to 3 lands. And then we answer the question in every land, because the answer is different. So can I tell them what to do? No, because they need to decide which of these 3 is most important to them. And you can have 10 clients come in with 10 different results because someone weighs something more than the other person. So as a general rule, gifts are bad. Okay? As a general rule. There are exceptions to every rule. All right. Now, what is a gift? It's a transfer of value. It's a transfer of an asset or an applicant for less than fair market value. All right. So here's my example. I paint your house. $10,000. Gift? No. Anyone else? Well, what's the fair market value of painting my house? It's $5,000. Really? Yeah. No, I made that up. I don't know. But if it was $5,000, do you see what I just did, right? I did the law school thing. It depends. If the fair market value to paint my house is $5,000, I now have a $5,000 for value transfer, and I have a $5,000 gift. If the fair market value to paint my house is $10,000, I have a for value transfer. So it all depends on fair market value. What is fair market value? Whatever third parties are willing to pay or to do for a service, right? So, if it's a public auction, that's about the best definition of fair market value, right? You open it up to the public comes and you get it, you're good. In a context where a family member is going to buy it, the county forces you to use the tax record times the common level ratio or an assessed value or an appraisal. You have to get an appraisal. If you've got 3 random non-family members bidding, that's fair market value. But once a family member becomes involved, they want to be careful because they don't want you playing shenanigans with the house. So we either have to use the tax value times the common level ratio or get an appraisal. All right, now with a gift, you're going to have a period of ineligibility, right? So if I receive a gift, they're going to cause a penalty. It is $482.50 a day. So essentially, that's what they're saying the cost of care is in the state of Pennsylvania. So if I gift 10 grand, I multiply that out or divide that out, and that tells me how many days of ineligibility the person will have because of the gift. Jeff, what's a 5-year look back period, right? It's how long back am I going to have to present 5 years of statements? So think of it this way. I put a box on the table and you say, okay, what goes in the box? 5 years of every account, 5 years of every statement, checking, savings, money market. Everything that's happened in the past 5 years goes into that box. Okay. That's the look back period. It's 5 years from the day I file an application. So if I've got a $100,000 gift that falls off next month, if I wait for a month, what am I going to do? I'm going to wait a month. I'm not filing the application. Who's in control of filing the application? We are. A lot of people mistake the penalty period with the look back period. They have nothing to do with each other. The look back period is how far back we look to see what goes in the box. The penalty is, okay, once I determine what's in the box, because of gifts that you've given, what's the penalty? They have nothing to, you see how they are not one and the same. I might intentionally give a gift away tomorrow, which we will in a minute. That doesn't mean I have to wait 5 years, right? No. I have to serve the penalty based upon how much I gifted. I'm not waiting 5 years. So just remember that, because that's going to come back here in a minute. Look at the chart. Oh. So now it's getting a little bigger, right? We have the non-exempt money going to the nursing home resident. We have the spend down amounts transfer for value or exempt transfers. So it's getting a little fuller now. Now we're going to talk about a community spouse. So that means we have somebody who is at home. We call it the well spouse or the community spouse. We're going to allow them to keep assets. All right, so let's just go back. Let's take a minute and go back. What is the community spouse allowed to keep? A house, right? A car. The community spouse retirement account. Remember those 3? All right, now we're going to take everything else. His assets, her assets, his retirement. I don't care how it's titled. Put it in a pot. The community spouse is allowed to keep half, no less than $27,480, no more than $137,400. All right, so if the pot is 40, what can they keep? $27,480. If the pot's 100, what can the community spouse keep? 50. If the pot's 500, what can the community spouse keep? 137,400. We good? All right. When you ask the public, how much can the community spouse keep? Everyone's going to say what? Half. I hear it everywhere. And they're not even saying the house, the car, the community spouse retirement account in half. The answer is half. Is half true? No. Nope, not true. All right, these are just assets. What about income? All right, so for income, we're going to have sort of the same thing that we have to do. For the community spouse, we want them to have a certain amount of money. The minimum amount of income is $2,178. Jeff, what if the community spouse's income is $3,000? No problem. They keep the $3,000. What if the community spouse's income is $2,000? Now we're going to allow them to keep $178 a month from the institutionalized spouse to get them up to $2178. Jeff, what if the community spouse's income is zero? We'll allow them to keep an amount to get them up to $2178. You see how that works? Now the community spouse gets the income to get them up to that minimum. Whatever's left, the institutionalized spouse gets to keep the $45 personal needs allowance, and then the remainder goes where? To the nursing home for the cost of care. We good?
Can we define spouse? Is it, do they have to be legally married?
Yes, legally married.
So what if you have a companion, would it make sense at some point to get married, to get the benefits? Is there a look
Yeah.
period on that?
I got to tell you something. No, there's no look back period on that, but I have to tell you, when you're sitting in a room, now I've never done this. I want to be very clear. I've never done this, and I mean it. But when you're sitting in a room and there's like companions, we'll use that term, and you know how much can you protect if they're married? 100%. If they're not married, the best you can do is protect 50. It's hard not to tell them to go get married. Right?
Shouldn't they just figure that out?
Well, I mean, sometimes I don't want to, because here's the other problem. Who am I protecting 100% of the money for? The spouse. The other spouse may have kids to another relationship. There might be a prenup. Now, what we would say is, let's pool a family together. Let's have the kids work out an agreement with the spouse that she'll give the money back. Like, there's a way to benefit everybody here. Because once you're married, your assets are at risk. So the spouse is taking on a risk by getting married. Second marriage situations, when people are in their 70s and 80s, they get a prenup. And they think, well, we got a prenup. Everything's good. Who's not a party to your prenup? The state of Pennsylvania. They didn't agree to that. They didn't know. Spouses' assets are counted, right? I mean, you saw the rules. So it just gets complicated when there's kids to another relationship, because what I say to the kids is, guys, the best you're going to do is half. She can keep 100%. What if we work out a deal where she'll keep 100%, she'll keep 25, and you get 75, and everybody wins? She keeps 25% more than she would have, and you get 70. There's a way to work this out. Let's be smart about it. Usually it doesn't work that way. Usually someone's stupid and they won't listen. So, all right, so we get the income as well. Now, triple M&A, minimum monthly maintenance needs allowance, is what we're talking about when we talk about the 2178. We may exceed it if the community spouse has exceptional circumstances resulting in significant duress. As far as bars go, what would you put this one? I'm putting this one high. All right. The only situation where I've ever seen them allow us to go above the maximum amount of income was where the community spouse was actually living in a facility himself for $5,000 a month. So they allowed us to essentially keep a little more to keep that person able to stay in that facility. But normally you're not getting over the minimum. 2178 is really what most people are getting. To get up to the maximum, you got to show out-of-pocket costs for utilities and other expenses. To get above that, you better show somebody died. That was really funny. You just missed the joke. All right, fine.
And that's all for the well spouse, correct?
Say that again?
That's all for the spouse that's well.
Yes, this is the income that we want them to keep. Yeah, we want them to continue to be able to live a lifestyle that they're not impoverished. These are called the impoverishment rules. So, all right, now here's where we have fun. So let's go back to our example. I think it was Paul and I were having a conversation. So let's say there's 530,000 of assets. We know that the community spouse can keep the house, the car, the community spouse retirement account, and what? Half, but no more than 137, right? So as I said, there's 537,000 of assets. You see, I just screwed up. So what we're going to do then is we're going to say, okay, the IS can keep how much? Let's say 2,400. The CS can keep half, but no more than 137. So we have an excess amount there, right? We have 537. They're allowed to keep 137, which means there's 400,000 left over. Does everybody agree with my math? All right, 400,000 left over. We believe the law says pay the nursing home 14 grand a month until you get down, and once you're down, you qualify. Correct? Right. So what we're going to do is we're going to take 400 grand. We're going to divide it. We're going to take the person's income plus the amount coming from the annuity, and I do not want it to exceed 20 grand a month, keeping it under. We're going to make equal payments to that person with a Medicaid qualified annuity to pay out all 400,000 until they end up with all of it. So does anyone have a calculator? What's 400,000 divided by 18? 18,000. I'm just using 18,000 by the
400,000
yeah.
divided by 18,000,
18,000, yep.
22.22.
22.22. So that means that this qualified annuity is going to pay to the community spouse for 22 months. Equal payments until he or she has 100% of the money back. So now she's back, or he's back to 537, right? We're back to the full amount. They got all of the money back from the qualified annuity in 22 months.
What about if it's half of non-exempt resources up to 130,074? How can you be putting 400,000 in? Wouldn't you have to have?
So there was 537 in my hypo to start. I left 137 in the person's name. So the community spouse has 137 to start, but now there's 400 left over that I either have to pay to the nursing home or I have to get back to the community spouse. Does that make sense, Denise?
Yeah, but I thought the whole thing was that the equal or the half non-exempt resources meant that they got half of that. So
No more than 137.
Right.
Yeah, you cannot exceed 137. So what people think and what the nursing homes believe, and I've had admissions director tell me this constantly, we thought you had to spend down to 137. No, the law says either you have to spend down to 137 or you have to, because essentially what a qualified annuity is it's a legal way to take an asset and turn it into an income stream. They look at the value of the community spouse's assets on one day in time. The day that you put this plan in place where you purchase the Medicaid qualified annuity, that's the day that they look at the community spouse's assets. Then we want 100% of the money to come back to the community spouse. Now, notice that I used a pretty large amount. I said 400,000. That takes us 22, 23 months to get it all back. In most cases, if you're able to get 18 grand, 19 grand back to somebody in a month, you can get most of what's left back pretty quickly, right? Those are short term. How many companies in the country want to get involved in 2-3 month qualified annuities? What do you think? Zero. There's no money in it, right? There's no money in that. So there were a few visionaries, I'll call them, who back when OBRA 96 and DRA 05 came out and saw the law, they went to a couple companies and said, hey, will you allow us to be the exclusive provider of Medicaid qualified annuities for 3, 4, 5, 6, 7, 8 months? Well, only 2 companies bid, right? Because they don't want them. There's no money in it. But with volume, potentially you can make money, because if you're the only companies that are doing it, when you're 36 months and above, Nationwide is in that pocket. You know, Nationwide has a product at 36 months and above, and then everybody else comes back into the market at 60 months. But the problem is, if I can get this money back to the person quicker, I want to. Because remember, one of the requirements of a Medicaid qualified annuity, oh, it's not there. You must name the state of Pennsylvania as a beneficiary. So I want that term to be as short as possible, right? I want that community spouse to get that money back to him or her ASAP. So when you're doing 2 months, 3 months, 4 months, you know, you have Elko and you have American Century. They're the 2 companies that are essentially doing 2, 3, 4, 5, 6 month annuities. And then there's a person who can broker them they get to keep the money from the processing fee. It's not, there's only 2 individuals out there. It's not our firm. We have nothing to do with it. They get the processing fee. The company gets the annuity. Once it's over 36 months, they'll share fees, and like Nationwide comes back into the fold, so most people can get licensed with Nationwide. The problem is these other companies don't want anything to do with it because they don't want a short-term annuity. But I just had a conversation with an advisor recently, and I said, understand that if we don't do this, they're going to spend 14 grand a month until they're broke. This way, you get to keep 100% of the money. Every month, $18,000 is coming back to you. You reinvest it every month until you put it all back. And he wasn't understanding that part. He was thinking he was losing all of it. He's going to get it all back. He won't lose any of it. But we have to do this in order to be able to get it back.
Kind of quick point for the financial advisors in the room. My understanding, unless this has changed, is that this particular strategy, for a financial advisor, it's actually illegal for us to propose this strategy. It has to be proposed by
Really?
an attorney.
Okay,
That's
so
my
what
understanding of it.
I believe what Paul said was it's actually illegal in his understanding for an advisor to propose it, that it has to be proposed by an elder law attorney.
It's the same thing with advising about the look-back period.
Oh, really?
We're not supposed to tell them about.
Okay, so the other advisor in the room said we're not supposed to advise as to look-back periods either as a financial advisor. So, well, that's why you come here.
How long has this been in place?
Since DRA 05 and OBRA 96. It's been in place essentially since the federal laws allowed Medicaid planning, essentially.
I ran into the situation with my father-in-law, and we went to an elder lawyer, but this was never discussed.
Well, you know, so the elephant in the room, and it was just brought out, was we worked with an elder law attorney for my father. It wasn't discussed. We had to spend down all the money. We hear that every day. We hear that scenario. In fact, I will not name names. We've stayed out in Lancaster for years. I mean, I've been practicing 20 years. I didn't come to Lancaster. And then we started having a lot of cases. So I teamed up with who I was told by a whole bunch of people is the expert. And I said, great. Hey, I called him. I said, would you pay me a referral fee if I send you these cases? Because lawyers are allowed to share referral fees. And then I won't have to come across the river. I'll stay in York, you stay in Lancaster, and life will go on. 2 significant cases, like protecting $750,000 to $1 million of assets. Both clients came back to us and said, he has no idea what you're talking about. You can't do this. You have to spend the assets down. He thinks you're crazy. I said, I am crazy, but for other reasons. Don't mix this up now. So we ended up doing both cases, and then we ended up coming to Lancaster because we could not find anyone who understood how to do it.
Yeah, in our situation,
What's that?
I said, he wouldn't believe me.
no, in
Oh.
our situation, we didn't do the spend down. We took the risk because my father-in-law was in bad health, and we figured, we had 9 months to break even. So that's what we did, and worked out really well. But
Well, you got lucky.
yeah,
Yeah. So what he said was they basically rolled the dice, took the money, and then hoped he would die. And he died, right? You got lucky. So it doesn't always work out that way. And then who would have been personally liable? All the kids. And the one thing I want to highlight is we had this case. The parents gifted the money to the grandson for the wedding and for the honeymoon. 20-some thousand for the wedding and the honeymoon. What are the chances the grandson has the money 4.5 years later? 0, right? Person was told by the nursing home to spend down the assets. They listened to the nursing home. They got spent down. They filed the application only to find out 4.5 years ago this $25,000 gift existed. So the nursing home did some pre-discovery and litigation and found out what every child was worth. Who do you think they sued? The child that's rich. Yeah, and the child that's rich was mad. It wasn't his son that received the money for the wedding. And do you think the nursing home cared? No. I don't care who's owed the money. You have all the money. You're the rich one. You pay us. So, yeah, it worked out in your case because he didn't live too long, right? So that's why that worked out. But had he lived a long time, that would have been horrific. So,
From personal experience, I had an elder law relationship over in Lancaster, and they had introduced me to the Mutual of the world, American Centuries. And from what he was gathering, the other gentleman concluded, yeah, there definitely needed to be an elder law attorney to basically create that paper trail and that referral back to, as a insurance licensed person, I could be set up directly with them, and then from there I was compensated obviously through doing one of their Elko Medicaid SPIAs.
And you were compensated?
Uh-huh.
So it must have been beyond a certain amount of months, because they don't share under a certain amount. So it must have been probably over 36?
Yeah, it was
Okay.
39 months.
Perfect. It was 39 months in that case. So they do pay a referral fee over 36. Yeah. And they're good about that. All right. That was married. The rules are different for a single. So let's talk about a single individual. Anyone heard of half and half plans? Right? The older people in the room, you're smiling a little bit. Jeff, didn't they get rid of half and half with DRA 05 and OBRA 96? And what's the answer? No, because I wouldn't be talking about it if they did, right? So it's just a different dance now. So let's use a hypothetical. I have a single individual enters a nursing home. They have $200,000 of resources. They have 2 kids. They're not married. All right, so what I'm going to do is I'm going to evaluate the income of the person and what they have. I'm going to evaluate the cost of care to the nursing home. Then I'm going to give a gift of, let's say, half. So I'm going to gift $100,000 to the 2 kids. And when the 2 kids get the $100,000, what happens? I get my hand slapped. What did I just do? I gifted money within the what? 5-year look back. So I have to wait 5 years, right? No!
Why?
Because the look back period has nothing to do with the penalty period. The look back period is only what goes in the box of statements, remember? The penalty is based upon how much money I gifted. So if I gifted $100,000 and I divide that by $14,676.04 a month, or $482.50 a day, that tells me how many months I'm penalized. So I did a $100,000 gift. Boom. Divide that out. Let's just call it 10 months because we're not going to get that fine with details, with numbers. So I'm penalized for 10 months. That means I'm still private pay for 10 months because I don't qualify for Medicaid yet, right? Yes. All right, so what if I take the other half, $100,000, pay that out over 10 months, which is the penalty period, plus the person's income, and it's going to equal just shy of the private pay amount of $12,000 a month. Why did I say just shy of the private pay amount?
$2,500.
Yeah, because it has to be shy. If their income and the qualified annuity equal the private pay amount, you'll never qualify for Medicaid. There has to be a shortfall. The people who received the $100,000 gift, where do they take the shortfall from? The gift. They're sitting on $100,000. They take the $40 a month for 10 months and give them the shortfall. So the nursing home got paid in full for the 10 months. Jeff, what if the person dies in month 5? Was Medicaid paying anything yet? No, there's a penalty period. So in a single case, I never have to worry about the state taking any of the money. Yes, the state is listed as a beneficiary up to the amount of care that was provided, but the state will never receive anything because there's a penalty period. Only when the penalty period ends does Medicaid kick in. You see it? So I'm not worried about if they die, the money just pays out to the beneficiaries. So there's no risk to the family in a single case, right? Essentially, they're hedging the bet. They're betting that the person's going to live, and they don't want to pay more than half, right? In this case, we bet they weren't going to live, and we won. So they're just betting in that case, okay, I think they are going to live longer. Like, let's just say they have dementia or a health thing that's going to let them live a long time. I want the worst that I can do is to lose half. And that's how these half and half plans come in place. Prior to the rules, we never gifted the money to the kids. We left the money in the individual's name. OBRA 96 and DRA 05 said you can't do that. As long as the person has money in their name, they're over-resourced, they'll never qualify. So now they force the gift to the kids. Then we can go ahead and do the half and half plan. Are we all following? All right, look at the chart now. So now we're adding the community spouse resource allowance, CESRA, and we're allowing potentially a qualified annuity. Waiver. Community health choices, right? The name recently changed. Same program, still allowing benefits in the program, but there is a waiver income cap limit. The waiver income cap limit is $2,523 a month. If the person receiving the care's income is over $2,523 a month, they cannot qualify for the waiver program in Pennsylvania. Now, there is a little bit of play with about $500, okay? For the fact finders in the room, when I used to teach this nationally, we were taught that there's two types of states. There's income cap states and there's non-income cap states. We're a non-income cap state. For the states that have income caps for their Medicaid program, you're allowed to create what is called a qualified income trust or a Miller trust. So essentially they create this trust, they funnel all the income through it, it spits out on the back end, and so really there's no income cap limit, right? They can end up having any amount of money. So when I came back from teaching nationally and I heard our waiver program has an income cap limit, I started arguing with the state of Pennsylvania, saying the federal law allows qualified income trusts. They allow this, they allow Miller trusts. It's codified. You have to allow it. No, we don't, and we won't in Pennsylvania. You can fight it, you can do it. So we kept insisting, and every time we would lobby them and we would try to, and then all of a sudden out of nowhere, DHS says, well, we're going to allow not a qualified income trust. No. An excess income trust. We're going to allow an excess income trust up to $500 a month. But it's not a qualified income trust. Please don't mix it up. They're different. What? So there's a $500 wiggle room is essentially what I'm saying. So really it gets up to like $3,000 of income a month, which we can still qualify them, but you can't go over $501. It's only $500. I don't understand it either, but it is the rules. Here's where this is significant. What counts as income for the applicant? Social Security, pension, long-term care insurance. Do you see a problem? Why did the people buy the long-term care insurance? To stay home. By having it, what did they just do? They can't qualify. I don't get it. It doesn't make sense. Shouldn't that be exempt? I mean, you should encourage that. So unfortunately, I've had some advisors call me and say the premiums are doubling, the benefits are cut in half. They're under the waiver cap limit currently. They're way under the income cap limit, but with the long-term care, they're not. So in a couple situations, they stopped paying it because they were like, look, this is only going to screw me in the end and it's not going to help me because the benefits are going cut in half. Now, I'm not suggesting that they're not valuable. Dan said exactly what I say is I think long-term care insurance is worth its weight in gold for in-home care. You don't need it for the nursing home. I just proved to you why you don't need it. But nothing I can do can keep you home. If you're over that waiver limit, and $2,500 a month is not a lot. It's really not. We get a lot of people who don't qualify because of that waiver limit, the income cap limit. So I don't understand it. I think you'd want to encourage people to having it. And I think that Pennsylvania discourages it because of that waiver income cap limit. Jeff, why is there a waiver income cap limit, but there's not one for the nursing homes? Anyone want to guess? Whose lobbyists were bigger? The in-home care providers or the nursing homes? I think we all know the answer to that. Let's keep moving. So Frantic Mary, this is a real case. I did change her name to protect the innocent. She was all about keeping her husband home. Unfortunately, he was well over the income cap and well over even the $500 excess income trust limit. There was no way to qualify him for waiver. He was up all night because of his Alzheimer's. She didn't sleep. Ultimately, we had no choice. We had to place him. He was wandering all night long. It was a great success story. Up until COVID, she was there every day for 12 hours a day with her husband. At night, she got to go home and sleep. And then they took care of him during the night when he was wandering and belligerent and fighting and yelling. She loved it. she was extremely excited. Now, when she first learned that she couldn't keep him home, you could imagine it was not a good conversation, but it worked out in that scenario. She is back now visiting him. The COVID restrictions have lightened up, so. We did a couple examples, I think, as we were going. Does anyone have any questions about how qualified annuities work in a married or in a single case? No. So the community spouse does not have an income limit. So if the community spouse's income is $8,000, the community spouse keeps it. No, they won't get to keep any of the IS. The IS will go to the nursing home. Oh, thank you, Angie. I really appreciate you asking that question. The biggest difference between waiver and nursing home, Medicaid. When you're getting care in the home under waiver, they are currently not keeping any of the income of the person receiving care towards the cost of care. The waiver program allows the household to keep the income to keep the household going. So that's nice. But what happens is the community spouse gets used to that. And then when they end up having to be placed in the nursing home and they potentially lose that income, that's where it becomes a little touchy. But that is nice. They do allow that.
Isn't there a state recovery though too, once the spouse would pass away?
So the question is, isn't there a state recovery too once the spouse would pass away? So there is, but it's only how much money is in the applicant's name alone. So let's go back to our scenario. The institutionalized applicant. Did anyone notice that I said, let's keep them under 2,000? Did anyone pick up on that? I'm just curious. The limit's 2,400 or 8,000. Remember that? We always try to keep every applicant at 2,000. And here's why. Even if you're allowed to keep 8, anything over 2,400 when the person dies, when the applicant dies, the state of Pennsylvania gets to be paid back under a state recovery, anything that's in the applicant's name alone. So if I keep $7,000 in their name and they die, they're going to recover that. But here's the sad part. They're going to require you, the family, to hire an attorney to raise an estate and charge $3,500 so the state can get the other $3,500. Well, the family doesn't win anything, right? I mean, that's such a crock. So what we always tell people is, forget that you think you're allowed for your applicant to have $7,000. You can't do anything with it. There's no benefit to it. Let's get them under 2,400 so that we don't have to raise an estate and there is no right for the state to get recovery. The money that's in the community spouse's pocket is the community spouse's. They don't recover against the community spouse for the care for the applicant. All right, so watch this. Back to our example. Spouse ends up with all 570. Remember? Qualified annuity paid out, 22 months, ends up with 100% of it. It's protected from whose nursing home? The spouse's, not mine. What do you think I do with the 570? I'm going to put it into an irrevocable grantor's trust. I'm going to let it sit there for 5 years, and then what? It's 100% protected. Right? So the first part is protecting it for the spouse from the spouse's nursing home. The second part is protecting it from the well spouse's nursing home in the future. Because it's one thing to protect it, but if you ultimately lose it, did you really protect it? Not really.
Jeff, do you think they'll continue to do it like this?
Here's my opinion. So Jackson,
A lot of money.
what's that?
They're giving away a lot of money.
So Jack's question is, do you think they're always going to allow this? Here's my opinion. Notice the V. What's on this side? Pre-planning. What's on this side? Crisis planning. I think the right side goes away. I don't think that they can allow forever putting $1 million back in the community spouse's pocket, right? I just don't see how it makes sense. What I have been told and what I believe is that the pre-planning will always be in existence. Every legislator I've talked to says, do you know how much small? I mean, I went to one that I'm friends with and I was talking to him and I said, you're losing so much money. And he chuckled and laughed and said, Palomo, you're not that big, dude. Like, I don't care how big you think you are, you're not. Think of an average of how many cases you're doing in a month. How many other people in the state of Pennsylvania are doing it at your level? I said, I don't know. He said, none. I can answer that for you. Right? So I think it's a big deal because we do it all the time, right? We've got 60 cases going on pretty much at all times, but we're a firm that specializes in it. There aren't many. So I think the crisis will go away. I think there's a day where they say, if you don't plan ahead, we're not going to let you do this anymore. I don't see how they get rid of the pre-planning because the pre-planning is based on common law trust principles. It'd be very difficult to say that you can't do this. It would be really easy to say you can't do this, right? These qualified annuities, you know how easy they would be to get rid of? Congress just passes a law. Gone. I guess Congress could pass a law with that too, except that's based on trust principles. It's going to be a lot harder to go after that than it would be to go after this. So what we tell people is for the people that are in the homes now and in the next 2, 3, 4 years, you're fine. For the kids in the room, for us, don't rely on this. Plan for this. You want that now to get it in under today's rules. So that if they do change it, you're fine. But I don't think they will change this, but you need 5 years, so you got to plan ahead. Does anyone else have an opinion on that? That's been my opinion forever. I think they're going to get rid of crisis. I do. I think they have to.
Furthering your discussion, going back to why you set the payout on the annuity at $18,000, was that to get that $400,000 transferred as rapidly as
Yes.
possible, so you can begin the second step of protecting the community spouse for 5 years?
100%. So his question is, why $18,000 a month? Why under 20 total, right? The reason for that is because the state, there's a lot of case law about these annuities, and the Third Circuit in Zaner held they were fine, they're allowed under the law, they're good to go. Pennsylvania sort of alluded to the fact that they don't want the income to be over 20 grand a month for the community spouse. Now, you're not going to find an income cap limit in the federal rules. You're not going to find it in the handbook. You're not going to find it anywhere. That's what they've sort of told us. So because we don't want to be the poster child for another lawsuit, we're basically all just agreeing. We'll just stay under it then. Just stay under the number. If they're agreeing that they're okay with that, that's a lot of money. You know what I mean? If you can get up to 20 grand a month of income back to a community spouse in a month, that's a lot. So I don't feel like I need to be a pig. I'm okay with it. We've had a few cases where we've done 21, 22, we've gotten away with it. You know what? I don't need to push the envelope. Why? So we're just following their rules, but we always maximize it. I always want to get it back as soon as possible. In the community spouse context, that's necessary because the state has to be named as a beneficiary up to the amount of care. With the single individual, they never pick up benefits until the private pay is over, until the penalty ends. So it doesn't matter in a single case, but in a married case, I want to get it back as soon as possible so that the community spouse can keep 100% of it. I think this sums it up. And it also goes to Jack's question, right? We recommend pre-planning, right? If you feel at all like we're saying, oh man, we love crisis, and we don't. We would much prefer you do a plan ahead 5 years ahead of time, right? No stress, easy peasy. I truly believe that the government's never going to care about it because you're giving up rights for 5 years. Every legislator I've talked to is, man, if you plan ahead like that, good for you. Good for planning. Good for following the rules, right? That's no different than a millionaire taking advantage of tax deductions on their tax return. It's the exact same thing, right? So follow the rules. Use what's available. Our opinion is it's much better to do this than it is to use the crisis rules. Currently we can, currently they're working, and we're good to go. But we always believe that the pre-planning is better for everybody, particularly the family. Who bears the brunt of the stress in a crisis case? It's not the parents, it's the kids. Because they got to go get 5 years of statements. They've got to be the ones. And what do you think they know about the parents' finances? Nothing.